Good morning, everybody. Then, 2nd of October, 2014. Nothing has happened. I just forgot to press the button record, along with my good colleague, Malgorzata Sindeka, Associate Professor on State Aid Issues. We have the pleasure to introduce to the University of Bergen, Cees Dekker. He's a lawyer working in Amsterdam and Brussels on state aid and competition law. And he's going to talk to us about state aid or how public financing impacts or even makes possible the energy transition. Cees has been working on this over 30 years. He teaches at some really great universities like University of Amsterdam. He has also taught in the University of Groningen, where some of you might study. And he has plenty of experience litigating cases before courts. And he is a very interesting person individually, but also as a lawyer, because he represents both the state and companies in different type of cases. So he really has two different hats to discuss some of these issues. So Cees, I'm not going to say any more for now. I'll hand you the word. The floor is all yours. Just make sure that your mic is on. And if you want to move the slides, just click here. This should be working. And thank you so much for joining us in Bergen. The floor is all yours.
Thank you, and thank you for having me. It's a pleasure to be here. And the advantage of introducing me twice is that you clearly improved in pronouncing my name. So it's Cees, like in case law, so it's very easy. And well, to add something to the kind introduction, I'm a lawyer in private practice for many years, over 30 years, and specializing in competition law in the last 20 years, more and more focusing on state aid law. I'm not only involved in energy case or energy transition cases, but I also do state aid cases on infrastructure, environmental protection, etc., the whole field, all sectors. And we have a special experience with Simmons & Simmons in doing notifications for government bodies, notifications, I will come to that, but notifications of state aid measures to the European Commission in order to get a positive decision. And positive decision means that you get a decision of the European Commission saying that your state aid measure, the national measure, is compatible with the internal market. I will refer also to the EEA agreement because we are in Norway after all, but I will focus on the TFEU. Let me start with a story. This is the map, as you see, of Spain, and this map shows the hours of sunshine in Spain. And if you see that map, if we talk about energy transition, you immediately will think, well, that offers some opportunities for a photovoltaic energy generation. That was what Spain thought back in 2000, about that year. And Spain introduced some incentive measures for investments in renewable energy, mainly sun power, photovoltaic generation plants. It introduced some incentive measures, as I said, and that was very successful. Many investments in Spain for many billions of euros, all based on the measures Spain implemented in the beginning of 2000. It was a huge success, but after a while, it became very expensive for Spain, and Spain was economizing its measures. So it introduced with the initial schemes feed-in tariffs, we will come to that, feed-in tariffs, feed-in premiums. And after a couple of years, Spain was diminishing those tariffs. So the consequence of that was, of course, that the investors got a lower yield than expected when they were investing. And they started, many of them started arbitration procedures. They didn't go to the Spanish courts saying, well, you promised me to give these advantages, but they started arbitration procedures on the basis of the Energy Charter Treaty. Arbitration procedures started by investors that were not established in Spain. So, for instance, Dutch investors starting arbitration procedures against Spain, German investors, etc., etc. Many of those arbitration procedures ended in positive awards for the investors. So the arbitrators awarded claims to the investors. And of course, they say Spain has to pay. The question now, and that's the reason why I mentioned this case, the question now is, because you can ask yourself, what is the relation with state aid law? The question now is whether Spain, if it pays the awarded amount to the investors, pays state aid to the investors. Well, the investors say, well, there is no question about state aid because we have an arbitral award. And so the procedure has ended, and that's what it is. Spain, you have to pay. We say, I say we because we defend Spain in this case, we say, no, the arbitral award itself is a state aid measure. And it's not declared compatible by the European Commission. Of course, you may say, well, this is a strange world. You introduced incentives, and on the basis of those incentives, we invested in good faith. And after we invested, you brought back the feed-in tariffs, the feed-in premiums. So what about our expectations about stability in your measures? Well, the thing is, it got wrong here, as at least from a state aid law perspective. Because here, Spain introduced those measures without asking the Commission for a positive decision, without asking the Commission to declare the investment schemes compatible with the internal market. So it started wrong here. This was an unlawful state aid measure. And according to the case law of the European Commission, a diligent business operator must normally be in a position to confirm that the required state aid procedure has been followed. So our argument here is there are no legitimate expectations because you had to check here as an investor whether the advantages you got from, you would get from the incentive measures of Spain were lawful state aid measures, were declared compatible with the internal market. And because you didn't, you can't invoke legitimate expectations, even if the arbiters, which are not European courts, and they cannot ask for preliminary questions to the Court of Justice in Luxembourg, even if those arbitral awards say you have to pay. That's not the European court that said you have to pay. It's not the European Commission that has the power, as the only institution, the power to declare state aid compatible or incompatible. So you didn't follow the proper procedure as Spain. But now we're in the situation that Spain has its obligations based on state aid law, saying that you are not allowed to pay state aid without a positive decision of the European Commission. So this procedures now also before the national courts are not ended yet. Of course, this is our perspective. Let me clear about that. The perspective of the investors is totally differing from ours. But that's, in a nutshell, one of the new state aid law problems that we see in practice, the relation between arbitral awards in this case and state aid law, the obligations coming from state aid law for member states of the European Union. So an interesting question would be if Spain really has to pay the aid. I have to add something. The investors ask, in some cases, in the United States, for leave to execute the arbitral awards in the United States, so they can seize possessions of the Kingdom of Spain in the United States. And we say, well, that would be paying state aid. If you seize our possessions, our Spain's possessions in the United States, we are actually paying you, and that payment would be state aid. So if they do execute the arbitral awards in the United States, we think we will claim back the unlawful aid paid in the United States from the investors here in the European Union. So very complex cases, and I thought it was interesting for you to see how these cases can evolve in practice involving state aid law. So that as an introduction. The next thing, the next question we have to ask ourselves, what would be the rationale for non-market interventions for state aid, for incentives to invest in certain developments? Many times I hear people arguing against state aid for companies, that you are helping the company. For instance, in the Netherlands, Tata Steel, the steel producer, wants to make a transition from fossil fuels to hydrogen generation for their industrial processes. And some in the Netherlands say, well, Tata Steel is a very rich company, and it's able to invest in India, for instance, in a hydrogen-powered steel plant. But I think that you shouldn't approach state aid law as a help to a company, but as an incentive to reach political goals. And that's what the Commission also says in the guidelines for for aid for environmental goals and energy goals. We will come to that. It's generally accepted, the Commission says, that competitive markets tend to bring about efficient results in terms of prices, output, and use of resources. Okay, so we leave it in general to the market. However, state intervention may be necessary to facilitate the development of certain economic activities that would not develop at all or would not develop at the same pace or under the same conditions in the absence of aid. So you're not helping so much a certain company, you're helping to promote a certain development which, as a government body, you consider important for the society. Of course, this is apart from rescue aid or restructuring aid that is focused on rescuing a certain company. But even then, you think as a government body that it's in the general interest of society that a company in problems will be restructured and can continue its activities. So your perspective is the general interest of the society. And if you, as a government body, think that the market is not working good to reach those developments you want to see to happen as a government body, there is a reason for intervention. There's a reason for state aid. So I think it's important that you use that perspective if you're thinking about, yeah, whether it's good to give state aid to companies or not. So, as Ignacio said, my focus is on competition law. Well, the broader competition law. That's what I did for many years, and state aid law is part of competition law. It's part of Title 7, Chapter 1 of the TFEU about the rules on competition, and Section 1 of that chapter are the rules applying to undertakings, so 101, 102 of the TFEU, and Section 2 is about the rules applying to state aid. They are focusing on the conduct of government bodies as opposed to Section 1 that is focusing on companies. So the question we should ask and we should answer is, how does state aid affect competition, and what competition, and what is the relation of state aid to the internal market? Have you any ideas about that? What's the competition part of state aid? Anyone? Yeah. I understand what you say, but it's not exactly what you say, because if you have a lot of state aid, then you are distorting competition. It's not about the amount of state aid so much, but if you give state aid to one company, for instance, the Dutch government body gives a company in the Netherlands state aid, but Germany doesn't, then the conditions of competition are distorted, of course. So that's the competition, not only between those companies, but also between the member states. If, for instance, Germany thinks we want to attract investments to Germany in energy transition in industries, for instance, they will give incentives with state aid, but that's distorting competition, not only between the companies that get state aid and those who don't, but also between, for instance, Germany and the Netherlands, because Germany attracts investments where probably the Netherlands don't. So it's not only about competition between companies, but also between member states. Okay, what will we do today? As Malgorzata already said, I'm specializing in state aid law. So my approach will from the state aid law system. And within that framework, I will tell you something about state aid for the energy transition. What we'll do is we will focus first on the notion of state aid. I won't go into every detail, but I will focus on some aspects of the notion of state aid which are relevant. All those aspects are relevant, of course, for the energy transition, but there are those that are most relevant for the energy transition. And that's the criterion of advantage and the criterion of state resources. And then we will go into types of state aid and compatibility in relation to the energy transition. Well, let's have a look at Article 107, paragraph 1. That says, save as otherwise provided in the treaties, any aid granted by a member state or through state resources in any form whatsoever, which distorts or threatens to distort competition by favoring certain undertakings, or the production of a certain good shall, insofar as it affects trade between member states, be incompatible with the internal market. Many people say that this is a prohibition on state aid. Well, you can argue that because it says state aid, which, etc., is compatible with the incompatible with the internal market. That looks like a prohibition. I also give a course on state aid law at the University of Amsterdam, and then I'll go into detail. Then I'll analyze the differences between Article 101 and 107 in detail, because they look very much the same, 101 and 107. But there are some differences that say something about the differences between the competition law system and the state aid law system. Just for to be complete for today, Article 61 of the EEA agreement says more or less the same as Article 107, paragraph 1 of the TFEU. So I said, this looks like a prohibition. State aid, fulfilling all the criteria of this article, shall be incompatible with the internal market. But if we have a look at Article 107, paragraph 2, that says the following shall be compatible. So this one says 107, paragraph 1 shall be incompatible. And then 107, paragraph 2 says about certain categories of state aid, the following shall be compatible with the internal market. Well, the most important one of this paragraph is aid to make good the damage caused by natural disasters or exceptional concurrences. On the basis of this paragraph, hundreds of state aid measures were declared compatible during the COVID pandemic. But that's not so interesting for the energy transition. So we go on with Article 107, paragraph 3, that says the following may be considered to be compatible with the internal market or the function of this the EEA agreement. Well, then it sums up a couple of categories of state aid measures that may be considered compatible with the internal market. Then we need to look at Article 108, paragraph 3, that says the Commission shall be informed in sufficient time to enable it to submit its comments of any plans to grant or alter aid. If it considers that any such plan is not compatible with the internal market, having regard to Article 107, it shall without delay initiate the procedure provided for in paragraph 2. The member state concerned shall not put its proposed measures into effect until this procedure has resulted in a final decision. What does this paragraph say? It says that there is an obligation for member states to notify intended state aid measures before they implement that measure to the European Commission. So any measure that fulfills the criteria of Article 107, paragraph 1 must be notified beforehand to the European Commission. There is a standstill obligation, the last sentence, the member state concerned shall not put its proposed measures into effect until this procedure has resulted in a final decision. So you have to wait for a decision of the European Commission saying that the aid is compatible. If it's not compatible, you cannot execute that measure. So you have to wait for a decision of the European Commission. Well, I give a reference to the EEA agreement, the Protocol 3, that says the same. So there is an obligation to notify before you want to implement a state aid measure. And what does that mean? Well, in combination with this judgment of the Court of Justice from 1977 already, in which the court says these provisions show that the prohibition in Article 92, back then, it's 107 now, is neither absolute nor unconditional, since Article 92.3 and Article 93.2 give the Commission a wide discretion and the Council extensive power to admit aids in derogation from the general prohibition in Article 92, paragraph 1. So the court here says that Article 92, 107, paragraph 1 is a general prohibition, but at the same time, it doesn't say that the prohibition isn't absolute nor unconditional. So my conclusion from this combination of provisions is that the state aid law system is a system of prior monitoring and supervision by the European Commission of national measures that qualify as state aid, rather than a prohibition on state aid. And practice shows that the prohibition is not absolute, because every year hundreds of state aid measures are declared compatible by the European Commission. And many, many more are even not decided upon by the European Commission, because they don't need to be notified according to, we will come to that, according to the general block exemption regulation, which is an exemption to the obligation to notify. So many, many, many measures each year are implemented, many state aid measures are implemented on the basis of an explicit positive decision of the European Commission or on the basis of the block exemption regulation. So it's hard to say that we have a prohibition on state aid in the European Union if so much aid is allowed. As I said, I think it's not so much a prohibition, it's a system of monitoring state aid before it's implemented in order to protect the proper competition between companies and between member states. So it's rather a prohibition on state aid without consent of the Commission rather than a prohibition on state aid as such. So further on the state aid law system, if a certain national measure qualifies as state aid because it's fulfilling all the criteria of 107 paragraph 1, there is an obligation to notify. If a certain measure does not fulfill all the criteria of 107, it's not a state aid measure, so there's no obligation to notify. Of course, if a member state thinks probably this is a state aid measure, you can always notify. And the outcome of that notification procedure can be that the Commission says, well, we don't consider this a state aid measure. So there is no decision needed. We will come to that as well. But normally, or not normally, if a measure fulfills all the criteria of 107, it's a state aid measure, and there is an obligation to notify. There's a standstill obligation. You have to wait for a decision of the European Commission. Then, at the end of the procedure, there will be a decision. If it's positive, aid is compatible, you can implement it. If it's negative, incompatible, you're not allowed to implement the measure. So this is the general rule. State aid measures must be notified. But there is an exemption to that obligation to notify. There are some exemptions. We have the so-called block exemption regulations. There is a general one and one for the agricultural sector and one for the fisheries sector. But I will focus on this general block exemption regulation, the GBER. In Article 3, the GBER says aid schemes, individual aid granted under aid schemes and ad hoc aid shall be compatible with the internal market within the meaning of Article 107 of the treaty and shall be exempted from the notification requirement. So this is an exemption from the obligation to notify. So if you want to know if you can implement a state aid measure without prior notification to the European Commission, you need to check whether you fulfill the conditions of the GBER. And that's important for the energy transition we are talking about, because the GBER, we will come to that also, the GBER has some articles on aid for, well, energy transition related projects. So there's an exemption to the general block exemption regulation. So the state aid law system will look like this. There is an obligation to notify unless a block exemption or the general block exemption regulation applies. Then we must have a look to so-called de minimis aid. Does anyone knows what de minimis aid means? De minimis aid is aid below 300,000 euros per company per 3 years. And the so-called de minimis regulation says aid measures shall be deemed not to meet all the criteria set out in Article 107, paragraph 1 of the treaty, shall therefore not be subject to the notification requirement in Article 108.3 of the treaty if they fulfill the conditions laid down in this regulation. Well, we won't go into detail, but we can see that state aid, I can't say state aid, a measure giving an advantage below 300,000 euros per 3 years to a certain company is not fulfilling all the criteria of Article 107, especially the criterion on the effect on interstate trade. It is considered that de minimis aid is so small that it doesn't affect interstate trade. It's important to see the difference between this and the GBER, because the minimis is about whether a measure qualifies as state aid. One of the criteria of Article 107 is that a measure affects interstate trade. If it doesn't affect interstate trade, it is not a state aid measure. So there is no obligation to notify. And therefore, there is no need to give an exemption to the obligation to notify. The de minimis regulation only says we consider these kinds of measures not as a state aid measure in the sense of Article 107. Therefore, there is no obligation to notify. Okay, so de minimis, no state aid measure, no obligation to notify. For that reason, if a measure is a state aid measure, you need to notify unless a block exemption regulation applies. Then we have guidelines and frameworks. For instance, the guidelines on state aid for climate, environmental protection and energy from 2022. And we have the temporary crisis and transition framework, the TSTF. Maybe you heard about these communications of the Commission. So the second one is called the framework. The first one is called guidelines. And they set out how the Commission will assess the compatibility of certain state aid measures. Sometimes people think, okay, when I fulfill all the conditions of, for instance, the guidelines, I don't need to notify to the European Commission because the Commission says in the guidelines, this aid will be compatible. Well, that's not what the Commission says. The Commission says, if you notify the state aid, according to the obligation to notify, we will assess compatibility along the conditions we have set out in the guidelines. So what they are saying is this will be our policy in deciding on the compatibility of the measures that are notified. So guidelines, frameworks, and other communications are no exemption to the obligation to notify. You still have to notify, but you can tailor your measures according to the conditions of the guidelines, because then you will know that the Commission will give a positive decision. But you have still the obligation to notify. And that's, for instance, apparent from point 7 of the guidelines on environmental and energy state aid, where the Commission says in point 7, these guidelines provide guidance on how the Commission will assess the compatibility of environmental protection, including climate protection and energy aid measures, which are subject to the notification requirement under Article 107, paragraph 3. So I'm always confused when people think they don't need to notify aid that fulfills the criteria of the guidelines, because it's explicitly in the guidelines that the Commission says this will be the way in which we will assess notified aid. Okay. The same goes for the TCGF in point 8. So to complete the state aid law system, we talked about de minimis, that's not aid, so you don't have to notify. We talked about the block exemption regulations, that's an exemption to the obligation to notify. So under the BER, if you fulfill all the conditions of a BER, you don't need to notify. If there is no block exemption regulation applying, or your measure is not a state aid, not de minimis aid, you need to notify, and then the Commission will take a decision on the basis of guidelines of or frameworks, or if the guidelines or frameworks do not apply because, your state aid measure does not fit in those frameworks or guidelines, the Commission can directly give a positive decision directly based on 107 paragraph 2 or 3. Mainly 3 in practice. Okay. We will have a look into the conditions, the criteria of Article 107, paragraph 1. Again, this is the text of Article 107, paragraph 1, and we will break that down, the text. What does Article 107, paragraph 1 says? A state aid measure, a measure qualifies as state aid in the sense of Article 107 if it has a state origin or uses state resources. And that's important for the energy transition, we will say. If the measure is favoring, gives an advantage to a certain company, certain undertaking. So you may know the concept of undertaking from competition law, hardcore competition law, so to say. That's the same notion of an undertaking as we use in state aid law. So if the beneficiary of a certain measure is not an undertaking, but for instance, a private person, it's not a state aid measure in the sense of Article 107. It's only a state aid measure in the sense of 107, paragraph 1, if it favors an undertaking. Next element of 107 paragraph 1 is there must be a distortion of competition, and there must be there may be an effect on trade between member states. So let us have a look to the criterion advantage. Advantage, according to the Court of Justice, is in particular measures which in various forms mitigate the charges which are normally included in the budget of an undertaking, and which, without therefore being subsidies in the strict meaning of the word, are similar in character and have the same effect. Those measures are considered to constitute aid. So an advantage, there is an advantage if a certain measure mitigates the charges which are normally included in the budget of an undertaking. So it lowers the costs that normally are borne by an undertaking. Further to the advantage criterion, the court said in 1996, in order to determine whether a state measure constitutes aid, it is necessary to establish whether the recipient undertaking receives an economic advantage which it would not have obtained under normal market conditions. Well, we have a specialist here on market conditions. You wrote a PhD thesis on the market economy operator principle, and the market economy operator principle is central in state aid law. Because if you, as a government body, you give a certain, let's say, amount of money to an undertaking, you need to assess whether that undertaking could get that amount of money under normal market conditions. Well, if we are talking about a subsidy, it's clear that you will not get a subsidy under normal market conditions. But on the other hand, for instance, if a government body gives a loan to an undertaking, you have to assess whether that loan is given under normal market conditions. So you have to look mainly to the interest rate that's applied. If a government body applies the same interest rate to a loan that a commercial bank would do, there is no advantage for the undertaking which it would not have obtained under normal market conditions. So even if the government is involved in giving that loan, there is no state aid. We saw, I showed you this one already from the guidelines, that the Commission says, however, state intervention may be necessary to facilitate the development of certain economic activities that would not develop at all or would not develop at the same pace or under the same conditions in the absence of aid. In other words, if the market does not what government bodies want them to do, you have to give them an incentive. And that means that you do something that differs from normal market conditions, because under normal market conditions, the development you want as a government body will not appear. So you are intervening in market conditions. And that means, per definition, that you will give an advantage in the sense of Article 107, because you give an advantage that it's not would not be received by the undertaking under normal market conditions. Okay, so no, yeah.
If I can ask something.
Of course.
Just a quick question, because I'm ignorant on this. So when you say on the previous slide that state aid would be to foster activities that will not develop at all in the same pace or same conditions, is this thinking, for example, okay, we know that offshore wind is very expensive, but climate change is on us and we need to mitigate climate change and we need to reduce greenhouse gas emissions. So this will be an example of this. So the government, it's allowed on the European law to say we will give money so that this is done much faster because the market is not ready to do it.
Exactly. But it's a bit too quick to say that member states are allowed under European law to do that, because you have to fulfill certain conditions before you can do that. But in general, you're correct.
Okay, because this is the discussion that is on every day on the newspapers in Norway. It's too expensive to do offshore wind. And the government last week actually said how much they're willing to give next year. And all the companies, what do you think they said? It's not enough.
Yeah.
They said it's too expensive. So they estimate that what is budgeted for next year is half of what they need to be able to develop the projects. And this is the richest country in the world. Yes. And here we have a question.
Yeah.
A lot compromised by different type of class. So when we hear about ways of subsidizing or generating market incentive, everything that we hear a lot is tax incentive. Tax the wrong way of doing things, and what we hear is carbon tax, use that as an incentive, and therefore direct the market onto less carbon intensive resources. And that way you're generating investment without getting too much money out of pocket, but instead of taxing people action.
Yeah.
be the comparison between I either you give some state aid and I incentivize with a certain pocket of money that might or might not be too much in the middle, or I instead tax a wrongful action that I want.
Yeah. Well, tax as such should also be assessed under the state aid rules. It's a very complex area of state aid law, because in general, you have to compare the general system of tax law with a certain rule within that tax law, and ask yourself whether that certain rule gives an advantage to certain undertakings. So if a carbon tax is introduced for certain undertakings, but not for others, that may be an advantage for those who don't have to pay the carbon tax. So it's this slide shows certain ways to give incentives, and carbon tax would be a negative incentive, but still it's an incentive to alter your conduct as industry, and it may qualify as a state aid measure as well, because if you say the normal tax system would be taxing companies at a certain level, let's say income tax, company tax, 25%, but those that are highly on fossil fuels have to pay 30%. You may wonder if that fits in a general tax system. And you may argue that those that are staying on 25% instead of 30% get an advantage paid for in any way by state resources, because the government loses income from those companies that are paying less tax than the others on 30%. So taxing is a way, it may be a way of giving incentives. Tax doesn't escape the state aid rules, as we know from certain cases. Commissioner Vestager decided upon, and in some of those she lost before the Court of Justice because they had a, well, let's say a wrong assessment, but others she won. And it appears from those cases, we knew that already, I think, as a state aid specialist, but it's clear from those cases that tax regimes do not escape state aid rules. You can't escape the state aid rules as a member state by using a tax regime. So I don't know whether that answers your question, more or less. Yeah. So if we are talking about benefits that are not in line with market conditions, that may be a subsidy. We make a distinction between investment aid at the one hand and operational aid at the other hand. And normally, the Commission is not positive about operational aid. It says, well, you can give incentives for investments, but after that, the undertaking should operate on market conditions. But we see, especially in the energy transition, that operational aid is used many times and is declared compatible by the European Commission. But whether it is investment aid or whether it is operational aid, both of these kind of aid measures are focusing on, well, on the one hand, lowering the costs of investment in the energy transition, and on the other hand, and that's more on the operational aid side, giving the undertakings a certainty about their income after they did the investment. So if you think, well, it's very risky to invest in an offshore wind park, for instance, because I don't know how the prices for energy will develop in the next 15 or 20 years. Nobody knows. But you think the risk is too high, you would be helped very much by, for instance, a feed-in tariff, which guarantees you as a generator of energy that you may sell your energy against a certain price, certain minimum price. That gives you certainty about the revenues of your investment, so that diminishes the risks of your investment. Investment aid is a totally other kind of approach. Then you say, okay, we will help you to lower the costs, but that's based on the predictions of a certain business case. Well, I'll give you an example. I have worked on, that's a coal mine water project, a very interesting use of abandoned coal mines. They use the mine tunnels for storing water. And on certain levels, the water will be warm, hot, 28 degrees. And on other levels, the water will be at 16 degrees. The water is stored in the mine tunnels. These are abandoned mines in the province of Limburg of the Netherlands. They use it, as I said, for storing water, and they use the different water levels, temperature levels to, well, we won't go into detail, but to create a heating and cooling network for the environment, for the buildings and houses in the environment of the vicinity of the abandoned coal mines. Okay, so you are investing in such a project, and you are making a business case for it. What kind of figures do you use? If you made a business case in 2019, prices for gas were very low. So the business case in 2019 would not be so positive, because the investment is very high in this system. But if you would have made a business case in 2022 after Russia invaded Ukraine, well, you know, gas prices were very high, and in the Netherlands, regulation says that heat and cooling networks have to use tariffs at the level of the normal gas price. So if that's very high, well, your business case might be positive, and then there is no need for aid. But who knows what the level of tariffs will be next year or within 5 years. So it's very uncertain for such a business case how to calculate the positive or negative outcome of that business case. The province of Limburg intended to give a subordinated loan of 40 million euros to this project against an interest below market level, because that was they consider that if you would use market level interest, the business case would be negative, and I think they were right on that. So a very low interest. Because you use a very low interest or lower interest below market level, that would be an advantage in the sense of Article 107. So state aid. Not so much the loan itself, but the difference between the applied interest and the normal market level interest. That would be the aid element. It was clear that against an interest at market level, there would be a funding gap. But you have to calculate the funding gap or the total lifetime of this installation. So that was 30 years. That's very hard to calculate, of course. And what I said, the question is, with what reference prices will which reference prices will I use? Because we don't know what the prices will be within 5 years or 10 years, etc. So it was clear that this project needed aid, and it was because there would be a funding gap if they had to ask for a loan from a commercial bank. So the province decided to give a loan, but it decided to give a subordinated loan because the project also needed loans from the market and finance from the market. A subordinated loan. And there we had a problem because on the basis of the GBER, you may give a loan up to 40 million euros against interest below market level if it's calculated on the basis of a certain reference system of the European Commission. The Commission has reference interests, and against those reference interests, you can calculate what the amount of aid is. Difference between the reference interest and the applied interest will give you the amount of state aid. But that reference, those reference rates from the European Commission only apply to senior loans and not to subordinated loans. So we had a problem there because the GBER says, I think this is here, this regulation shall apply only to aid in respect of which it is possible to calculate precisely the gross rent equivalent of the aid ex ante without any need to undertake a risk assessment. That's called transparent aid. So the GBER only applies to so-called transparent aid. The following categories of aid, the GBER says, shall be considered to be transparent aid comprised in loans where the gross grant equivalent has been calculated on the basis of the reference rate prevailing at the time of the grant. Here we had, as I said, a subordinated loan, and the reference rates are not applicable to subordinated loans. What we did is that we discussed this case with the European Commission, and we said, okay, we understand that we can't apply the reference rates because it's a subordinated loan. But we would be allowed under the GBER to give a subsidy of 40 million euros. So in that case, we would give 40 million euros to the project and we never would get anything back. Now we give a loan and we hope that we can get back the loan with a certain interest. Okay, below market level, but nevertheless. So what if we consider the state aid amount not by calculating the difference between the interest applied and the interest, the reference rate, but we calculate the aid as 40 million euros. So not the difference between the rate levels, but the loan itself. Normally, you wouldn't say that the aid is the loan itself. It's only the difference between the rates. But we said, okay, if we consider the 40 million loan as a subsidy, it would be allowed under the GBER. So what do you think? Can we go on with this case or not? And the Commission agreed with us that you can consider a subordinated loan as a subsidy and then make it transparent aid under the GBER. So that was of great help for this project because they could continue without waiting for a decision. Otherwise, we would have notified the aid to the Commission and had to wait for, well, at least 6 months, but normally it can go up to 1 year or sometimes more than that. I'm still in a case with the European Commission about COVID aid, which takes more than 2 years now. Yeah. So if it's possible, you want to avoid a notification procedure and you want to design your measures in such a way that they fit within the GBER. So in this case, at least for transparency, it fitted within the GBER. But nevertheless, you also have to fit within the other conditions of the GBER. And Article 46 of the GBER in paragraph 9 says that the aid intensity may reach up to 100% of the funding gap. So we had to calculate the funding gap of this project that should be more, at least, or should be 40 million or more. If the funding gap only is 20 million, your aid of 40 million is too high. The thing is, you could say, well, the interest, the difference between the reference rate and the rate applied perhaps would be less than 40 million, but because the lifetime of this project is 30 years, the difference between those rates would be more than 40 million or about 40 million euros. So that wasn't a solution. So as I said, we considered this considered it as a subsidy of 40 million euros, but then we had to calculate the funding gap, and that's very important for energy transition projects, that you need to show or need to know, if you apply the GBER, what the funding gap of such a project is. And how do you calculate the funding gap? You will need to know what the net present value of your investments is against the net present value of the revenues during the lifetime of the project. And if that's negative without aid, without a loan against a low interest rate, the funding gap, there will be a funding gap. So what you normally do is that you take the business case with a commercial loan. And you will see in these kinds of projects a funding gap, because the revenues during the lifetime are lower. The present value of the revenues, net present value of the revenues, is lower than the net present value of the cost of the project with this commercial loan. Well, then you know what the funding gap is, and then you can calculate how much state aid you can give to the project. That's all about investment aid. That's about subsidies. That's about loans. That's about guarantees you give as a government body to an undertaking in order to enable that undertaking to get a loan from a commercial bank. A guarantee as such is not a state aid measure. Normally, a commercial bank can give a guarantee as well, after all. But normally, you have to pay a premium to a commercial bank to get a guarantee. And the thing is, if government bodies give a guarantee in order to enable you to get a loan from a commercial bank, they either apply a premium that's below the normal market level, or they don't use a premium at all. So you get the guarantee for free. So that's the state aid element in guarantees.
So you know you have about 20 more minutes.
Yeah. So we are talking about incentives for investments in renewable energy projects, but we should also talk about phasing out fossil fuel capacity, closing down coal-fired power plants, for instance. The guidelines say in point 4.12.1 that only for early closure of profitable coal, peat and oil shale activities, state aid is possible. But before we apply the guidelines, of course, we need to know whether a certain compensation for closing down a coal-fired power plant is state aid at all. And there is a recent Dutch case in which the Commission, in which the Netherlands implied in at the end of 2019 a new law that said that all coal-fired power plants should be closed at the end of 2030. But for certain categories of power plants, the law said that they had to close at the end of 2020, so within a year after the law came into force. And there was one power plant in the Netherlands that fulfilled the criteria for early closing. And that was the so-called Hemberg power plant from Vattenfall. And Vattenfall, of course, was prepared to comply with this law, but said, well, that gives us a lot of damage because the lifetime of this coal plant is not over yet. So we forgo a lot of revenues from this power plant. So we want to have a compensation, and the Dutch law provided for a compensation in these circumstances. So here, the compensation was calculated as the present value of the net expected annual cash flows over a couple of years. And it was about 15 million euros, the compensation. And the Netherlands said, well, this is not a state aid measure because we compensate damages that are caused by a kind of partly expropriation of the Hemberg Centrale. Well, the Commission got to know about this measure and said, well, we start an examination of this state aid measure. And the Commission said, well, in line with case law, the Commission considers that where a measure solely grants to the affected undertaking the compensation for damages incurred, this compensation does not provide it with an advantage and hence does not constitute state aid in the meaning of Article 107. So if you pay damages as a government body that you caused to an undertaking, that won't be, under normal circumstances, state aid, because it's not a selective advantage for that undertaking, because all undertakings in the same legal and factual situation will have that claim to the government body for those damages. Here, the Commission, it isn't in the decision, but one of the considerations of the Commission was that this compensation was not established by a Dutch court, but by the Dutch administration. And the Commission said the Commission also considers that the legal framework is in place in Dutch law that may entitle operators whose rights as owners are affected to a compensation, and that it cannot be excluded that such right to compensation exists. But then the Commission goes on, however, on the basis of the information provided by the Dutch authorities, it cannot be concluded with sufficient degree of certainty that a right to a compensation exists in the present case. Therefore, it cannot be excluded that the measure confers state aid on the undertaking concerned. The Commission does not say that this measure is state aid. It says it cannot be excluded that this measure is state aid. And then the Commission says, well, it's not necessary to decide on the qualification of the measure because anyhow, we think it's compatible with the internal market. And then the Netherlands appealed from that decision, and in the end, the Court of Justice said, well, what you did here, Commission, is not correct. You cannot decide on the compatibility of a measure of which you didn't have that you didn't have qualified as a state aid measure, because they didn't. They only said it cannot be ruled out that this is a state aid measure. And the Court of Justice says, okay, the first step is you have to decide on whether a measure is a state aid measure, whether it fulfills all the criteria of Article 107. And only if the measure qualifies as a state aid measure, you can set the next step, deciding whether it's compatible or not. So the case is back to the European Commission. We don't know yet whether the Commission will consider it, will qualify the compensation as a state aid measure. The court didn't say whether the compensation is a state aid measure, because it only could say, it only was allowed to say whether the next step was correct. So again, it's back to the European Commission, and the European Commission has to decide whether a compensation not established by a court, but in an agreement, but based on general rules of national compensation, whether that will be a state aid measure or not. So this is very important, of course, in relation to closing down fossil fuels capacity, because there will many more cases in which, if you want to close that down, you have to compensate the companies involved, because they will have damages because of the closing before the lifetime of the plant has ended.
If I could add a little bit here on this, on context for the rest of the class. In Germany, for example, there has been a somewhat similar situation where the German government paid compensation for owners of nuclear power plants. So the nuclear power plants received money because they said, you have to close the power plant, which we know it was closed last year, but you will receive money because when we originally gave you the right to run a power plant with a license, that was planned for 40, 50 years. So they made the investment and they calculated that you will recover money over that period. So if you only cover 20 years out of 50, that means that you're running at a loss because it's so expensive to build it. So that is another example on this. And there has been a lot of discussions also, maybe not on state aid, but there's a lot of questions on whether this is constitutional or not from a perspective of private rights of the owners of the plants to get them remove the property, or at the same time, whether it's something that we need to do because of climate protection issues, that actually the government should not pay compensation because this is an activity that is so polluting, coal activity in the Netherlands, that we have this. And Cees did not mention this, but there has been some cases after the 2030 phasing out in the Netherlands of coal-fired power plants, where the Hague's Court of First Instance said to a company, you will not get paid compensation because between 2020 and 2030, you have enough time to plan what to do with this plant. So they said, even if you had invested and you thought that the plant was going to run for 2040, we will not pay you compensation, which from a traditional perspective of law, that is quite a lot to say because it's removing your private property and not getting paid for that. So just to give you a little bit of a flavor.
Yeah, we had the same kind of cases in other sectors as well, and it's consistent case law, at least in the Netherlands, that if you require the closing of a certain activity, if you grant a time that's long enough to get the revenues for your investments, there is no need to compensate that undertaking. Of course, if the lifetime of a plant, for instance, if they invested 5 years ago on the basis of a business case going until 2035, and you say, okay, we need you to close this plant within 5 years, there will be a reason for compensation. Okay.
Because I wrote a small piece on this Dutch case. Now I know how to pronounce the name. So it's
Hemberg, yeah.
As you noticed, it's a very important case where the court said that actually, if you want to assess compatibility, you have to first find out whether this is actually aid. And right now it seems reasonable, right? But just to go to this case, and especially to the Advocate General's opinion, the circus he is trying to do with this case is just unimaginable, because, I mean, all this type of arguments, oh, it looks good, so anyway, maybe it's this aid, but it's compatible, so it doesn't matter. It does matter. It does matter a lot, because it has a very big procedural consequence, and maybe you would like to add, you would like to give some aid in the future, and this aid will already have some impact on that. So actually being clear on what we are doing, it's extremely important, because as you see, the Commission has a lot of power. So we have to demand that they use this power in a clear, transparent way. And we had such a decision, so-called fudge decisions, when the Commission was saying, oh, we actually don't know when it's A, but probably it's okay. So let's move forward. No way, you're not moving forward. Not going to do your job.
Yeah. Well, to add something from a practitioner's point of view, sometimes in notification procedures, we are considering, is this a state aid measure or not, but we want to have certainty about the lawfulness of the measure, whether it's state aid or not. And then we avoid the discussion about the qualification. For instance, we say, well, this may not be an advantage, but let us assume that it's an advantage. We won't discuss this with the European Commission. Please give us a positive decision. Because if we want to discuss the qualification as a state aid measure, that will take extra time. And sometimes you need certainty within a certain limited period of time. And then we avoid the discussion on the qualification of aid. So I don't think this court decision will be a problem for that, because it's the government body itself that says, okay, we won't discuss the qualification. We just need a positive decision. That's what we want. And then, of course, we won't appeal that decision, because we wanted to have that certainty. Nevertheless, the consequence of this court judgment may be that the Commission does not allow that anymore. They say, okay, we won't discuss the qualification, just give us a positive decision. So if that's the consequence, at least in some cases in practice, that would hurt us, because it stands in the way of quick procedures. So, but let us continue. We can discuss this afterwards.
We have 10 minutes.
Yeah. So just a little bit about state resources. As you see in Article 107, paragraph 1, a measure is only a state aid measure if it's granted by a member state or through state resources. And especially if we are talking about things like feed-in tariffs or green energy certificates or feed-in premiums, the question is, are they financed through state resources? Because most of the times, the consumers are paying in the end. Well, we're always paying in the end for state aid, of course, but you know what I mean. First case I would want to mention is the Preußen Electra case, on the basis of which many member states thought that feed-in tariff systems, etc., would not be qualify as state aid, because they are not funded by state resources.
I can say just very quickly, feed-in tariff means that the government pays always an extra to the value of electricity sold in the intraday market, which in the day-ahead market, which is the market that we saw the other day in class. So the government gives you every time you sell something, no matter what the price is in the market, I'll give you €5 per megawatt. That's what a feed-in does.
Yeah, okay. And it's apparent, I hope, to you that that's an advantage in the sense of Article 107, because it guarantees a certain price, and under normal market conditions, you wouldn't get such a guarantee for a long time. So in Preußen Electra, the court said that the provisions of a member state which first require private electricity supply undertakings to purchase electricity produced in their area of supply from renewable energy sources at minimum prices higher than the real economic value of that type of electricity, and second, distribute the financial burdens resulting from that obligation between those electricity supply undertakings and upstream private electricity network operators, do not constitute state aid because there were no state resources involved. This advantage was paid by the consumers. So after Preußen Electra, many member states have thought that, well, systems like the feed-in tariffs were not state aid because there were no state would not state resources be involved. But after that, the commission, the court said in Van de Colère, Article 107 must be interpreted as meaning that a mechanism for offsetting in full the additional costs imposed on undertakings because of an obligation to purchase wind-generated electricity at a price higher than the market price that is financed by all final consumers of electricity in the national territory constitutes an intervention through state resources. And I will show you, let me see, in this is the Spanish system we discussed earlier on. The consumers pay to the retailer, and the retailer pays to the distributor, but then a certain, let's say premium the consumers pay goes into a settlement system that is operated by a government body, a government agency. And that is reason enough for the European Court and for the European Commission to qualify the measure as a state aid measure, because they say state resources are involved. If at one point a government body, a government agency is involved in distributing the amounts the consumers have paid to the generators. So the amount of money itself doesn't come from the government, but at one point they govern that amount of money to make a redistribution between the operators, the generators, the producers of electricity. It was the same case. In this case, it was a Czech case. And this system altered during, it was 2010, I think. But in both these cases, the commission, this is from a commission decision, the commission said, well, at one time, a government body, a government agency is involved. So again, the money itself doesn't come from the government budget, but they control it. They control the money coming from the consumers at one point in this whole process. And that's enough to consider the money going to the operators, the generators of energy, to consider it funded by state resources. So that's important to know. I will skip this and I'll make some remarks on compatibility. Compatibility with the internal market is established on the basis of Article 107, paragraph 3, as laid out in detail in the guidelines and frameworks. But the basis is Article 107, paragraph 3. And what the Commission always needs to do is weighing the positive and negative effects of state aid. That's what they are doing when assessing the compatibility of aid. And what it did in the GBER is beforehand weighing the positive and negative effects of the aid covered by the GBER. And they also are weighing the positive and negative effects in the guidelines and frameworks. So they, well, let's say, decided on those weighing process already in those communications. So the Commission needs to ask and answer the questions which positive effects until from a certain measure and which negative effects until from a certain measure. And what negative effects are we talking about? The negative effects on competition and on interstate trade. I will remind you that we only have to do with state aid measures if a measure distorts competition and affects interstate trade. So every state aid measure affects interstate trade. If it doesn't, it's not a state aid measure. The question about interstate trade and competition in the framework of Article 107, paragraph 3 is not whether it affects interstate trade or distorts competition, but to what extent it affects interstate trade and distorts competition in order to weigh the negative and positive effects. Let us have a look at 107 paragraph 3 under B that says aid to promote the execution of an important project of common European interest. That's important for our subject today, is compatible with the European market. Here you don't see the competition and interstate trade mentioned. So it matters whether a state aid measure is assessed on the basis of Article 107.3b or Article 107.3c. Just to illustrate the application of 107.3b, on the basis of that article, a couple of projects of common European interest are decided compatible, or aid to those projects. And on the basis of this communication of the European Commission. And I just show you, I think we share the slides after this class. I just show you 4 of the IPCEIs that are considered, or 8 for those projects that are considered compatible in recent years in relation to the energy transition. So we had a first on the battery value change, 3.2 billion euros, a second on the battery value change of 2.9 billion euros, and then a first one on hydrogen, 5.4 billion euros. And you see all the countries and companies involved. These are huge projects. And we have a second one on hydrogen, 5.2 billion. So recently, we think that with the inflation, what was it called? The Inflation Reduction Act in the US, the US is giving much more aid than Europe does. Well, I didn't calculate how much the US is giving, but the European Union is still giving much state aid to this kind of projects. May I have 1 more minute to discuss a final case? This is about all the articles in the GBER on energy transition that you can use to give aid for the energy transition. But one thing, yeah, this is a comparison between the GBER, the guidelines, and the TCTF, which sometimes is rather complex. You may choose sometimes on the basis of which you want to give compatible aid. But it's sometimes very hard, and maybe after this class you check on these conditions, all these conditions, and it's not always clear which is the right basis for a positive decision on the basis of the guidelines of the framework, or to give compatible aid on the basis of the GBER. But nevertheless, always check which basis for your case is the best. One final remark about this case, which is a very famous one, I think, in relation to the energy transition. And this is about state aid given by the UK no, it was a contract for difference. Perhaps you discussed that also, which is a kind of operational aid for the realization of a new nuclear power plant. And the Commission declared the aid compatible with the internal market, but then Austria, that opposes nuclear power plants throughout Europe, appealed from that decision. And one of the interesting questions here was whether the European law framework, well, kind of prohibits investments in nuclear power plants. And one of the arguments of Austria was that in the guidelines on environmental aid, energy aid, etc., but all other guidelines we have in the state aid law system, nuclear power is not mentioned and as one of the goals you can give aid for. But one of the, there are many important points in this judgment of the court, but one of the important points in this judgment is that the court said, well, that argument does not fly. The fact that these guidelines do not mention nuclear power as a object of common interest doesn't mean that you can't give aid to nuclear power plants, because we have to look at 107 paragraph 3 under C, which was the basis for this state aid. And that says state aid may be declared compatible if it promotes a certain industrial activity, if it promotes a certain sector. And it's not ruled out that the nuclear sector is one of those sectors you may promote. So before the Hinkley Point judgment, the Commission always said there must be, if you want to give aid to a certain project, there must be a common object of interest for the European Union as such. But after this case, the Commission left that point of view forced by the European Court, because the European Court said, well, we have that projects of interest in Article 107.3b, but 107.3c does not talk about objects of common interest. So that's not a test the Commission should apply when applying 107 paragraph 3. So again, because although it's not in the guidelines that you can promote nuclear power, there's still room directly on the basis of the treaty to give aid to nuclear projects. So that was what I would add to what I already said, and thank you for your attention and also your patience. Sorry, I'm run a bit out of time, but I hope you found it interesting to see what state aid rules do in relation to the energy transition and what the possibilities are. And There will be many more questions. I appreciate that of you, and but just one class is not enough to discuss all those aspects. Thank you very much.
Thank you so much, Cees. You gave us an overview over this topic, which is a very difficult task because I asked you to do in about 90 minutes an impossible mission, which is to try to explain what is state aid and then present it in the energy transition. But a few takeaways that if I were you, I would think about this. State aid is about whether governments or countries can promote on a particular activity that will not get done because of the market conditions are not there. And we have some limits into this, which is the point of state aid, because we don't want to create a big distortions in the market. So it is all about how we design schemes to promote activities without creating a massive impact in the European, let's say, level playing field between the different players. And in a way, it is pushing public investment into something to achieve a societal goal that is wanted. So, and we have seen different ways to doing it. It could be because you invest and then you give investment, for example, in the coal case on the coal mine that is utilized for cooling or heating water, which is very important because that's how you get hot water when you're taking a shower. And that's actually quite a lot of energy that is utilized like that. Or it will be to pay subsidies to producers of renewable energy because the price, it's not enough to cover their costs. So that could be another alternative. So that'll be my suggestion on things to keep in mind and to go into depth in here because this is much bigger. And as Malgorzata said, she has a course that runs of 10 classes on only this, where you can go into much detail into this. So we wanted to give you this in a nutshell flavor of what this is, because it's a completely different field of law that you might not be so familiar with. So we have very little time left, and I will see if there's any questions about that you want to ask for Cees. And I'll check what we have something online here, and I will stop the recording. So if there's any questions, then we can have free questions without being recorded.